Okay, so look, before we get into Tyson Foods, because no, let's just get straight into Tyson Foods. I think I've known you long enough, even though we've never met in person, that I know when you're pissed, when you're angry, irritated, genuinely frustrated. You seem to be at that point with Tyson Foods. You put out a tweet that said they were jerking my firm around, and I don't know. I don't want to commit you to pro bono work, but the tweet is still there, I presume. And that I don't know if it was tongue in cheek. You'll take files pro bono against Tyson. Explain to the crowd what's going on with Tyson Foods, and if you can, to the extent that you can, because I don't even know what happened to put you over what I believe your edge to be.
Sure. So Tyson Foods has issued a vaccine mandate for its employees. It originally tried to deny people religious accommodations, originally told them that pro-life beliefs are not real religious beliefs. They realized they were going to get sued over that and it was going to cause lots of political trouble. So they reversed course on that. But their way of giving people religious or medical accommodations was to constructively terminate them, put them on unpaid leave for 1 year. So I filed suit in Dyer County, Tennessee. We served Tyson very quickly and gave them the courtesy of responding before we filed our request for an injunction. Went through the process of scheduling it with the court. The court took time out to make sure the schedule worked. And while we filed we met our part of the schedule, we filed our motion for a preliminary injunction, and on Friday morning, and then Friday at the close of business, Tyson Foods sent notice that they had removed the case to federal court, even though there's no grounds. It's a patently frivolous motion to notice of removal.
Okay, so it's a notice. They didn't actually like totally bypass and get it removed. They just, despite the schedule.
In America, your notice of removal automatically removes it and divests the state court of jurisdiction. And what they know is that a federal court will take too long to rule on remanding it back to state court, such that it will be past the timeline for employees to get vaccinated. So they did this knowing, because I said, in fact, I had a call with the counsel. No surprise, big Federalist Society lawyer that represents him, Greg Grisham. I don't think he's related to John Grisham. If he is, he's like the evil bastard brother version of him. But he led me to believe that there would be no issues, no problems, that we didn't need to file anything on an emergency basis. Just let him know all of this, when clearly it was their intention all along to basically procedurally delay the proceedings by filing a frivolous request in federal court that a real federal court, if the federal courts were not so solicitous of big corporations, if a plaintiff's lawyer did this, they would get sanctioned by the federal court, because we didn't sue for monetary damages. We only sued for declaratory and injunctive relief. And they didn't sue on any federal claim. So there's no grounds for federal court to have jurisdiction.
And they agreed to something of a schedule with you.
That was my understanding. I sent the schedule. The court communicated the schedule. They didn't say anything in opposition at all. They were just sitting and wait to try to pull this tactic. And it's not a surprise they did it after close of business on Friday. So we couldn't seek any relief from anybody until Monday at the earliest. And Monday is the deadline for Tyson employees to effectively get vaccinated. If they haven't had the shot by then, they may be fired on November 1st. And they knew this because this was the precise subject we had discussed with them. And they're like, don't worry. So just dishonest. This is why I don't like the Federalist Society. For those people out there, at deep, they're they're solicitous of corporate power, not individual power. When they talk about liberty, they mean big business. But so, this was just not an honorable, honest way to go about it. I could have got a temporary restraining order or asked for one ex parte. I didn't do that. And I was rewarded for my kindnesses in this manner. So what I said was on social media that I will look at representing as many people pro bono as I can against Tyson Foods from now until I die. It turns out there's a lot of cases against Tyson Foods. Turns out there's labor issues with Tyson Foods, illegal immigration issues with Tyson Foods, monopolistic practices by Tyson Foods. So I'll take as many as I practically can. Won't be able to take all of them. But am looking at bringing suit against Tyson Foods in Kentucky, Wisconsin, Arkansas, North Carolina, South Carolina, and Texas within the next week or two. And because they've clearly they are behaving in a dishonest and dishonorable way, as some of these employees are 28-year employees, 22-year employees. This is there's no excuse for this. And it's who they are.
Let me ask you this on a personal level, Robert, because I know how I would respond to that or react internally. You get this on a Friday afternoon. It's those Friday afternoon specials that ruin your weekend, that ruin your faith in the practice. Personally, how do you internalize it and how do you respond to it? Does it ruin your entire weekend?
Well, I believe in, I'm from East Tennessee, so the home of Hatfields and McCoys. So I agree with Donald Trump that there is inherent value in reciprocating those who behave in this manner. That's why I believe in never forgive, never forget, and hold the line. And Tyson Foods has just earned themselves a target on that list. Now, I've had sort of sporadic dealings with Tyson Foods over the years. When I was a young intern for the AFL-CIO out of college, when I was in college, learned about how corrupt Agriculture Secretary Mike Espy was, and then President Clinton, as they wouldn't even do anything about Tyson's history of speed and chicken, other poultry processing companies operated their lines so fast that workers were losing their fingers. Tyson Foods didn't care, nor did the corrupt Secretary of Agriculture under the Clinton administration. So that was my introduction to Tyson Foods. And I've heard complaints about them over the years. But if they had handled this on the up and up, then it would have been one thing. But this was just, they were clearly sitting in wait, doing this the entire time. And it's just a dishonorable way to practice. It's not, they know that the remand should be rejected, or the removal should be rejected. It should get remanded. They're just playing a game. And the people who suffer are going to be employees who now take a shot they don't want to take, who they fear taking, that violates their conscience to take, because it's their only way to maintain their livelihood and keep their obligation to their kids. So and lawyers that do this to me, I pay back. I always pay back. I have a long history of paying them back, and I will do that here.
And now we've discussed it, but thus far there's no precedence. There's immunity that's been granted to vaccine manufacturers, government, et cetera, et cetera. Without getting into any, talk that can get you into trouble on YouTube, hypothetically, any incidents that come from this policy as relates to employees, would Tyson's, in theory, potentially be on the hook for those damages?
In my view, I mean, it's basically an open question right now. The EEOC originally said employers could be liable. Then they sort of backed off without clarifying that one way or the other. But there's already people that believe they have been injured by what Tyson Foods has done. So those people will be suing. There's people that have been terminated. Those people will be suing. Again, all they did they bought themselves a little bit of time, maybe force some people to take a shot, the consequence for which is just going to be a lot more litigation from now into eternity. Because after I pass on, I'm going to make sure there's lawyers around just dedicated to suing Tyson Foods. Because this is not behavior I accept from anybody. And unless you want a permanent, intelligent adversary, don't engage in dishonest conduct with me.
And the question is this: you get this notice on a Friday afternoon. Is it possible to move for, not ex parte necessarily, but an urgent injunction over the weekend, find the judge in chambers and get them to issue some sort of TRO?
No, because it completely divests the state courts of jurisdiction, so they can do nothing. So now only the federal courts can take action. And to get the federal court to expedite a remand request, you have to know which court it's assigned to. And because of when they filed it, it hasn't even been assigned to the court or in the PACER system yet. So this is why they did it the way they did it. They did it knowing that their Tyson employees would be screwed, and knowing that was the precise consequence of it. I mean, it's really ruthless behavior. So it educates me about who Tyson Foods is. Maybe their name correlation with the Nazi Tyson family isn't a coincidence after all. But I was still, I don't know why I was surprised, but I was still surprised to see this degree of conduct. But I give people one chance, and if they betray that, they learn to regret the choice that they made.
And not to play Monday morning quarterback, backseat driver. In retrospect, I mean, anything you could do to protect that wouldn't look totally crazy on your part in the first place.
Essentially, you just have to go into these cases assuming the other side is corrupt, will do everything possible to mislead people. Now, the courts don't like you to assume that. So if you go in and say, hey, this defendant's untrustworthy, you need to sign a temporary ex parte restraining order now. Courts really hate doing that. They would prefer for the other side to get their opportunity to object. And they tend to only do that for, the powerful and the politically protected and the politically privileged. So it's not likely that I could have done anything different than what I did do. but it establishes a basis moving forward. In other words, that they were given a chance to show their hand. They've seen it. The court has seen it. Other parties can see it. I mean, the only basis to try to claim diversity jurisdiction is that somehow I'm going to have over $75,000 in attorney's fees per plaintiff. I mean, it's a patently ludicrous, frivolous claim. That again, if the roles were reversed, a court would sanction me in a heartbeat and remand this sua sponte. We'll see what the federal courts do in the Western District of Tennessee, but there's a reason why the big corporations rush to federal court. Historically, they've been very solicitous and deferential to big corporations, and that's the problem.
And people should appreciate that. I mean, this is one thing that really irritated me about the practice is like you go in there and you either are hyper aggressive, hyper accusatory, or you're hyper like, I want everything in writing. I want you to sign this. I want you to confirm via email. And when you do that, you end up looking like the crazy person. And then you end up getting stabbed in the back on a Friday afternoon for giving that one benefit of the doubt that would have made you look bad to assume you would not have gotten. And nobody's really going to understand it. I had this one file, which I will never forget, where, they basically did not send me undertakings, or they disjuncted one page from an undertaking. I only found out about it because it came in by accident through somebody else. I went to court and they said, well, you didn't ask for that. You asked for this email, but not the attachments. I was like, but nobody cared. At the end of the day, even the judge is like, don't waste my time today arguing over this. You have it now. Move on with your file. And for you, I mean, they'll get back in a week or two, and you'll be in the proper jurisdiction or wherever, and they'll say, I don't want to hear about this fight among lawyers. Get on with your file. That's part of the stomach-turning aspect of the law. But I guess speaking of the Tyson company, the class action lawsuit that has been filed against them, one of the lawsuits you sent me today or yesterday. Bottom line, I mean, summarize the lawsuit. It's one employee seeking for class action relief on the basis of a class so similarly prejudiced, which is that he was not paid apparently for any overtime, in that he was working upwards of sometimes 80 to 100 hours a week, whereas he should have been getting paid overtime. One thing I didn't really understand, or the nuance, is how do you distinguish between a salaried employee versus an hourly rate employee who's entitled to overtime? Whereas if they're on a salary, it's work whatever, and if you're not, then you get time and a half. How does that work, and how's it going to pan out in this lawsuit?
The kind of employment that he describes is hourly employment. And so some employers have tried to get around overtime laws by relabeling an employee a salaried employee. But there are specific rules to prohibit that in cases exactly like this. And so what he's describing is that Tyson is systematically and systemically violating the rights of their employees to overtime payment by mislabeling and misidentifying them as salaried employees, given the legal restrictions and restraints on who can be so labeled. And so it looks like he's got a very robust claim. And I think, it's a very strong claim. I mean, it turns out, like I said, Tyson Foods has a lot of problems, which, now will get a lot more of my attention than it did before. But this highlights another case where Tyson Foods appears. It looks like he's got a very strong claim. It's a very smart labor lawyer that's bringing the claim. Employers try to get away with this all the time. And I think it's because Tyson Foods operates in a lot of small, rural, blue-collar jurisdictions. They're used to running roughshod over any kind of opposition in their employees and treating them as badly as they want to treat them. And treating them as badly as they treat the chickens. And so I think it's, but what is smart people are learning to fight back, and smart lawyers are joining the effort. And that's another example of it.
I'm curious because I didn't see the contract, so I just didn't know how you circumvent hourly rate employment versus salaried employment. Whereas if they say we're paying you $80,000 a year and you're expected to work X amount of hours, if you work more than those hours, how does it work? I never got that far into labor law, at least those specific questions. But without getting into too much detail, so that's going to be the bottom line. This employee is alleging hourly work, but they were qualified as contractor or salaried employee, so they can work them more than they would otherwise get away with had they been an actual by hour employee.
Exactly. The nature of the work he describes for various certain rules under federal law require he be treated as an hourly employee for the purposes of overtime protection. Yet an employer cannot just relabel you salaried employee and magically escape overtime protection. It depends on the kind of work you're being done, the expectations given, other legal limitations that define when they have to pay overtime. And they have to pay overtime regardless of whether they call you an hourly employee or not. That's based on independent legal standards based on what kind of work you're doing.
All right, excellent. Now, the intro, did we get into the update as to where you stand on the Tyson Food lawsuits for the vaccine mandate issue?
So I have to try to get that case remanded back to state court. And so we'll see what the federal court does, whether it does it on an expedited basis or not. But also looking at bringing another half dozen suits in another half dozen other states concerning the same matter. So looking at several cases in Texas, several cases in Arkansas, several cases in both North Carolina, South Carolina, and Kentucky, and cases in Wisconsin, and looking at more as well. So we can only handle so many realistically, but I'll probably bring about a dozen cases against Tyson Foods related to just this issue, not just the other issues where I'll be setting up shop, but just this issue. There are more suits are coming on behalf of employees because they are religiously discriminating against their workers. And given where they sell their food and where they get their workers from, they're basically slapping their local community in the face. And people like Sarah Huckabee Sanders, she wants to be governor of Arkansas. Well, it's time she take a stand publicly. Is she going to sell out to Tyson Foods, or is she going to say what's happening here is wrong? She and her father have advocated for strong religious conservative rights against religious discrimination. Well, here's a good chance to show who you really are, show your real colors. And I hope she takes the right move. And if she does, she'll be the next governor of the state of Arkansas.
And I guess if we've talked about it, but briefly going over. So the issue with Tyson Foods is that they did not initially provide religious exemptions. What was the accommodation that they made that's actually no accommodation at all?
You have no job for a year, no pay for a year, and maybe your job will be here in a year. It's firing. It's firing without calling it firing. That's what it is.